also greet the departmental officials as well as the board, if there are members of the board present, and our support team from the NCOP. It is already 10 o'clock. We are going to be engaging on the Public Service Commission Bill, B30B of 2023. And this is one of the Section 75 bills that will require us to source the opinion from stakeholders, as we are going to be conducting that business today, and also to engage with the department to respond on the issues that will be tabled today by stakeholders. Let us declare this meeting officially opened. Mr. Manele, are there any apologies besides the apology of COSATU? Mr. Meth, who have indicated some commitments, but there is a delegation, Mr. Matthew Parks, there is a delegation which will make representations. Are there any apologies, Mr. Manele?
Good morning, Chairperson. Chair, from the committee side, we got one apology from the Chief Whip, Honorable Moema. Thank you very much, Chairperson.
Thank you. Am I audible in terms of the voice and everything? And am I appearing on the screen?
Chair, in terms of appearance, you appear clearly and the voice is loud and clear, Chairperson. Thank you.
Thank you very much. Having taken apologies, can we get a mover for the adoption of the agenda, honorable members?
I move, Chair. Greeting, Chairman. I move.
Okay, Honorable Makesini move. Honorable Bedenost, you support another. Thank you. With that being adopted, our agenda duly adopted. As the NCOP, we carry a responsibility of passing laws as Parliament, but also ensuring that public participation is guaranteed in every aspect of work that a government does, and also to ascertain that we play oversight over the executive. So today we are conducting one of those core responsibilities to source opinions from our stakeholders who have got keen interest on the proposed bill, which will affect them in different ways. But as a committee today, we'll be playing a role of listening, not being judgmental, but we'll seek clarities on your representations that you'll be making. Then after you have made your representations, we'll then request the department to come early next year to come back and respond to the issues that we have tabled. Then from there, we'll process the bill and make our inputs. But we'll expect that when you engage with us, you engage us in a manner that you feel is going to make your message come through to this collective, and also be open in raising issues, whether you are for or you are against. We value all the inputs that will be made before this committee. So we declare this meeting open without any further delays. We are now going to be requesting Mr. Avin Bola, coordinator of the Local Government Advocacy and Learning Network, which represent 80 civil society organizations. We are now giving you the opportunity. You must stick to the time allocated. We'll see if there is something that needs to be considered as we process. By 1 o'clock, we should have been done so that we can join other meetings. Mr. Epula, I'm sure you are ready. You can take the podium, and the team have granted you the permission. Over to you. Thank you.
Good morning, Chair. Thank you so much. I just want to put this on record that this is the only committee that really takes public participation seriously. I do a lot of advocacy work, and most of the institutions try their utmost to bar you from public participation. Thank you. My submission is based on the fact that the trade unions, for example, would comment on aspects that would affect them, and also that other laws have been taken into account. So we didn't want to entrench onto those parameters. Thank you. So just to start, I'm the advocacy coordinator of the Local Government Advocacy Learning Network, and this is an initiative by the Democracy Development Program. The network comprises of 80 civil society organizations operating across the Durban metropolitan area and the KwaZulu-Natal provinces. We engage with all tiers of government to advance lawful governance, procedural accountability, and public participation. Okay, just the executive summary of the Public Service Commission Bill. What I've picked up is that this submission presents a clause-by-clause review of the Public Service Commission Bill, grounded in Section 196 of the Constitution of South Africa. The bill seeks to regulate the composition, appointment, powers, and operational framework of the Public Service Commission. While the intent aligns with constitutional requirements, the current draft exposes procedural gaps, definition ambiguity, and enforcement weaknesses that must be corrected to uphold institutional integrity. The submission identifies and addresses the following shortcomings, which will be covered later as we go along. The qualification criteria for commissioners are vague and open to subjective interpretation. The phrase "other related fields" lacks definition and must be replaced with a prescribed schedule of disciplines. The appointment process lacks transparency and independent oversight. There is no mandatory public disclosure of shortlisted candidates, no scoring rubric for evaluating fit and proper status, and no independent vetting panel to prevent internal bias. Definitions with Section 1 are incomplete and circular. Terms such as employee, executive authority, and public administration require clarification to prevent jurisdictional drift and ensure accountability. The bill does not enforce timelines for committee action or presidential appointments. There is no consequence for procedural delays, weakening with the integrity of the appointment process. The Secretariat's role is undefined in terms of operational boundaries. It must be explicitly barred from issuing directives or recommendations independent of the Commission. The bill lacks safeguards against politicization. There is no cooling off period for recent political office bearers, and no requirement for conflict of interest declarations during the application process. Implementation of Commission decisions is not backed by enforcement mechanisms. There are no penalties for non-compliance or escalation protocols to higher oversight bodies. This submission provides fully drafted amendments for direct insertion into the bill. Each clause is framed to close loopholes, reinforce transparency, and elevate the Public Service Commission's constitutional mandate. The bill is a critical opportunity to entrench merit, integrity, and accountability in public administration. It must be strengthened with precision and legislative discipline. I will now go on to the sections that we have picked up and that needs closer scrutiny. Amendments to Section 4. Our argument is that Section 4 outlines the procedure for appointing commissioners, including referral timelines, qualification criteria, and public notice requirements. While constitutionally anchored and procedurally structured, the section lacks operational safeguards to ensure transparency, consistency, public accountability. Gaps identified: no scoring rubric to guide candidate evaluation, no public disclosure of shortlisted candidates, no mandatory conflict of interest declaration, no public objection channel, no escalation protocol for missed timelines. Our suggested insertions are the following: The committee referred to in subsection 2 must apply a standardized scoring rubric to evaluate candidates based on qualifications, experience, integrity, and independence. The short list of recommended candidates must be published within 15 days of finalization, including anonymized scoring outcomes. Each candidate must submit a signed declaration of financial, political, and relational interests, which must be made available to the committee prior to final recommendation. Any member of the public may submit written objection to shortlisted candidates within 10 days of publication, which must be considered by the committee before final recommendation. If the committee fails to act within the timelines prescribed in subsection 2 or 3, the Speaker of the National Assembly or the Speaker of the relevant provincial legislature must escalate the matter to the Rules Committee for urgent attention. Amendment to Section 5. Our argument, Section 5 defines exclusion criteria for candidates deemed not fit and proper under Section 196(10) of the Constitution. While comprehensive, the section lacks a procedural safeguard for candidates wrongly disqualified due to outdated, incorrect, or misinterpreted records. Suggested insertion 1 is a candidate who disputes a qualification under this section may submit a written appeal to the Speaker of the National Assembly or the Speaker of the relevant provincial legislature. The Speaker must refer the matter to the Rules Committee for review within 15 days. Amendment to Section 6. Section 6 regulates commissioners' external activities, term renewals, voluntary exit, and removal procedures. While procedurally structured and constitutionally compliant, it lacks operational safeguards to ensure transparency and accountability. Gaps identified: no performance evaluation framework prior to renewal, no publication of renewal recommendation or suspension proceedings, no review interval for suspensions. Suggested insertions. The Commission must adopt a standardized performance evaluation framework for commissioners. This framework must be applied prior to any renewal recommendation. The Commission's recommendation for renewal must be published within 5 days of submission to the President. Any suspension or removal proceedings initiated under subsection 8 or 9 must be published within 5 days of commencement, excluding personal identifiers. A suspension under Section 10 must be reviewed every 30 days by the President. The President must publish a summary of the review outcome. Amendment to Section 7. Section 7 empowers the President to designate one commissioner as chairperson and another as deputy chairperson. It also provides for temporary substitution if both are unavailable. While procedurally functional, the section lacks safeguards to ensure continuity and transparency in leadership transitions. Gaps identified: no publication required for designations, no limit on repeated temporary designations. Suggested insertions: the designation of the chairperson and deputy chairperson must be published in the Gazette within 5 days of appointment. No commissioner may be designated as acting chairperson under subsection 3 for more than 2 non-consecutive terms within a calendar year. My closing statement: this submission reflects a complete section-by-section review of the Public Service Commission Bill B330B 2023 as received and reviewed. Amendments were proposed when necessary to correct procedural gaps, reinforce operational clarity, and ensure constitutional compliance. Each clause was assessed for its enforceability, transparency, and alignment with institutional mandates. This concludes the submission. No further comment. Thank you.
Thank you very much, Mr. Bula. You were within the time allocated, but you were able to cover a detailed presentation. Thank you very much for always availing yourself whenever we present the opportunity to the stakeholders. Thank you very much.
Mr. Chairman, can I just take the opportunity of wishing everyone a festive season because I think this is the last engagement for the year. Thanks a lot. Much appreciated.
Indeed, everything of the best to all of us. Thank you very much. Honourable members, as we normally conduct this, we don't engage unless if there are clarities that you want to seek from Mr. Bula on what he has presented, any specific clarities. If it's clear, I see Honourable Mzimande.
No, it's just a simple question. Chair, I wanted just to check whether in relation to a proposal of operational safeguarding, does he not think that can only be covered at a level of regulations? Why in the bill? If I can have a rationale out of this. Thank you.
Thank you, Honourable Mzimande. Any other member? Honourable Kaza?
No, thank you. It's clarity, Chair. Just to check, man, you state that each clause of the bill was assessed for enforceable transparency and alignment with institutional mandates. Can you clarify the exact constitutional framework or jurisprudence you applied to determine these alignments, particularly regarding municipal autonomy under Section 151 to Section 155? Thank you, Chair. That's my claim.
Thank you. Those were the only two clarities. Over to you, Mr. Paul.
Okay, the first one, I didn't hear clearly. The Wi-Fi was a bit bad. The person buffered a bit. If you can just please repeat.
No, the issue that I was asking relates to the operational safeguarding statement you have used. I was asking whether that can it be accommodated on the regulations rather than to the bill.
Yeah, okay. This is what I said in the beginning, that, I looked at perhaps various pieces of legislation that can take care of this. And I didn't want to hog up the time with this. Yes, that's a possibility, and that shouldn't be a problem. Thank you. Okay? The second one, the Public Service Commission bill, I'm just trying to get clarification from the person that asked the question regarding the municipal part of it. What clarity did you need on that? Because in the legislation, it doesn't refer to the municipalities. If you can just clarify that part. Thank you.
Yeah, maybe, Honourable Kaza, that's an engagement we should be having after we have considered all the representations, and when we engage with the departments. Let's just allow the presentations to flow, then we can engage during that period. Does that cover you?
Yes, Chair. Indeed, it does. It does. We don't want to stretch.
Thank you very much. Thank you very much. Thank you, Mr. Bula. Please remain behind so that you can also hear other representations, and when we summarize at the end. Thank you very much. We can now move to the next presenter, which is South African Local Government Bargaining Council, which is represented by Mr. Lance from SALGA, Lance Joel, Mr. Craig Adams from Imatu, and Dr. Dumsan Makakula from SAM, Nobala. That's a representation we are now welcoming. I didn't declare upfront that I once served in SALGA, so when you see me knowing some of the colleagues there, don't be surprised. I was a mayor before. Over to you, Mr. Lance and the team.
Well, good morning, Honorable Chairperson, Honorable Kaunga. At least you are able to indirectly declare that you once went with SALGA. You may see a different face. I hope you saw Lance Field closer to me. My name is Nelson Kutu, the chairperson of the South African Local Government Bargaining Council, EXCO, from the Labour Union. SAMU is the president in terms of my position. What we are going to do, Honorable Chair and the committee, is that we are going to have a presentation from the bargaining committee through Mr. Lance Vuel and Greg Adams. But as you know, the bargaining committee is a body that is comprised of labor, which is SAMU and IMATU, as well as the employer body, SALGA. That's why our presentation will be represented by two, Mr. Lance Vuel and Greg, who will share the platform in terms of presenting the position.
Yeah, get a meeting for the public hearing. Yeah.
Sorry, Mr. Manele, can you mute Mr. Manele? Mute your line, please. No, Pala, we are not getting you clearly. I don't know whether it's your reception where you are located, but you can proceed. We'll see if it's getting improved.
Can you hear me? I'm the president, not the secretary.
Oh, okay. Yes, sorry, President.
Yes, but I'm here standing as the chairperson of the EXCO Bargaining Committee. Like I said, our presentation will be done by Mr. Lance Vuel and Mr. Greg Adams on behalf of the Bargaining Committee, which is a body that is comprised of employer body, SALGA, and the two trade unions, SAMU and IMATU. We are going to go over them an opportunity to present on the behalf of the Bargaining Council so that they are able to take us through what become our comments in relation to the bill at hand. Mr. Alonso.
Thank you very much. My apologies, Mr. President. Once a Nobala, always a Nobala, but President, my apologies. I hope you accept that. Thank you. Over to you, Mr. Lance.
Thank you very much, Honorable Chairperson, and greetings to yourself and the honorable members of the Select Committee and the leadership of SAMU, IMATU, and SALGA that are all present on this platform. That's how serious we're taking this matter, Chairperson, and then all other guests on the platform. I will deal with the first few slides, and then my colleague, Craig, will do the remainder, but the presentation will still be in line with the allocated time frame. So if you go to the next slide, Chairperson, these are the four areas we are going to cover. Just on the overall view from our perspective as parties to the Bargaining Council, what we think are the constitutional weaknesses within the bill itself, practically display what those are through given examples. And then lastly, we will deal with some of the direct referral, labor relations, timeframes, as well as the employee of choice matters. On the next slide, Chairperson, to get into the detail, the president of the Bargaining Council, or the chair of the Bargaining Council, president of SAMU, has indicated that we had worked together on this input jointly, while SALGA consulted with its municipalities as members. SAMU and IMATU have similarly done a consultative engagement with their members, being municipal employees. And we have emerged with this product that, whilst we largely support... Sorry, Chair.
Let me recognize you, Honorable Peter.
I'm sorry, Chair. I don't know whether my gadget is not well, but I can't hear the honorable member properly. It just repeats time and again. Can I be assisted maybe by the IT? Thank you, Chair.
Thank you very much, Honorable Peter. Yeah, the line is not that clear. We don't know if Mr. Lance, you can get another better position. As you proceed, you get cut off.
Apologies for that, Chair. I have now changed the connection line, and I'm hoping it is much better. Is that so, Chair? If I can get that confirmation?
Yes, if you can come close to your mic,
Okay.
or you increase
Okay.
your volume.
No, that's fine.
Thank
That's fine, Chairperson. I hope that's much better. So in the main, whilst we support the integrity, accountability, and in particular the fairness on the public administration, and what is ultimately the objective of this bill, particularly as it relates to the Public Service Commission, there are areas that concerns us. In the main, it relates to what has already been raised through a question. It is the encroachment on the authority of local government as a sphere of government, the role of municipalities themselves vis-a-vis not only other spheres, but also constitutional structures. And then lastly, some of the detail related to those. If we can get to the next slide, and the idea, Chair, is not to workshop the select committee on how government is structured, but merely to make a point that we do have three spheres of government. We don't have tiers of government. We have three constitutionally recognized spheres of government, which are distinctive, they are interdependent, and they are interrelated. But the important point we would want to make through the slide is that all three of those spheres have been allocated constitutional powers and functions that they must execute, whether concurrently as two spheres together, or whether alone as a sphere of government. On the next slide, the Constitution goes further. If we can move to the next slide, the Constitution goes further by then recognizing the fact that each of those spheres must perform their functions. But the important point is what you see in the middle of the slide, is that as it relates to local government itself, a municipality has the right to govern on its own initiative, the local government affairs of its community, of course, subject to national and provincial legislation as it is provided for in the Constitution, and that others may not compromise or impede on a municipality's ability or right to exercise those powers and perform those functions that have been appropriately allocated. So there is a constitutional safeguard. We call it local government autonomy, that there are constitutional powers and functions allocated to local government as a sphere, and they have the responsibility as municipalities to execute those powers and functions without anyone encroaching on their ability to do so. And now, Chair, having laid that foundation, I will hand over to...
I'm going to deal with the more practical problems that we are encountered with the bill. And I think one of the best place to start will be what we believe are to be the constitutional problems with that bill. Just want to get, and that core constitutional problem that lies between everything else. Now, we understand that the bill for the first time is extending this commission's powers into local governments. Never done that before. But we're of the view, and we will explain that the Constitution actually doesn't give the Commission that power and authority, especially in respect of the grievance powers that is set out in the bill. Now, the Constitution section I refer to is section 196. And in that section, there's very different references made. Some parts of section 96 refer to the powers in the respect of the public administration, and other parts refer to powers in respect of the public service. Now, the bill itself has a definition of what public administration is and what public service is. And on public administration, that the bill describes as national government, provincial government, and local government. And the Public Administration Management Act does the same thing. But on the public service, that is described as only being national department and provincial departments. And section 196, subsection 4F, subsection 2, actually gives the Public Service Commission the power to, number one, investigate grievances of employees in the public service and recommend appropriate remedies. Now, these are the three parts: investigate grievances in the public service and recommend appropriate remedies. And I think this is where the bill has a major shortcoming. So the first part is that the grievance jurisdiction clearly applies only to the public service. And as we've indicated before, the public service is defined as national and provincial government in the bill itself. So if it says that the PSC is given the power to investigate grievances of employees in the public service, then surely that cannot include local government. And that's, I think, where the core problem is with the PSC's extension of powers into local government. And that's where it first of all starts. Then the second part that it says that the PSC may only issue recommendations in grievance matters, not binding directives. And that is a very clear line that's being drawn by the Constitution. But the bill, in fact, actually ignores both of those limitations. First of all, Section 10(2), and now as well in the latest version of the bill, Schedule 2 at the back, gives the PSC the powers to investigate municipal grievances. And it also gives the PSC the power to issue binding directions, which the Constitution only says can be done through recommendations. So that would actually now change the role of the PSC from an advisory body, which the Constitution actually says, to some sort of command authority in a local government. Now, when we raised one of these points with the PSC, they indicated, no, they're not necessarily relying on the grievance clause. They rely on an earlier clause, Section 194D, which says that the PSC can investigate personnel practice in the public administration, and they can issue binding directions. And they indicated that they're relying on that clause for the basis for the grievance clause. But that's what's called a general provision versus a specific provision. And there's a long-standing legal principle that says you cannot use a general provision cannot override a specific one. The principle is called generalia specialibus non derogant. So in other words, you cannot say that there's a general provision that I can investigate public personnel administration and then said I'm using that to also have a grievance mandate under that. But the reason is because there's a specific provision in the Constitution that regulates how grievances can be investigated. And on that basis, I think that's what the main core problem is with the bill, in that it's actually, in fact, unconstitutional. So if Parliament wants the bill to have binding grievance powers over municipalities, to first of all have a jurisdiction over the municipalities to begin with, and also have binding grievance powers over that can only be done through a constitutional amendment. It cannot be done through ordinary legislation, which is what the bill is doing at the moment. So on that basis, we believe that these provisions in the bill are constitutionally vulnerable, and there's a big chance of it being found unconstitutional. Next slide, please. Then the constitutional concerns are maybe just the first problem. I think the practical considerations are the next aspect of it. So again, getting back to Section 196, 196(4) F2, as we indicated, the Constitution, and let's for a moment take away the argument whether public service or whether public administration. Let's assume for a moment that the bill is correct and it does have the powers over local government. It says that it can investigate grievances. But the bill goes much further than that. It in fact goes and redesigns how grievances must happen in local government. So effectively what it does, first of all, it overrides the main collective agreement. Now, the local government already has a binding 3-step grievance system. It says that if you bring a grievance, it must follow 3 steps. It must be brought to an immediate superior, then taken to a head of department, and from there it can go to a municipal manager. So every municipality must follow that. There's Section 71(3) of the Municipal Systems Act that says every municipality must follow a collective agreement. So that there's no choice on that. It's not a guidance. They must follow that. But now Section 68A of the bill, I think that's in subsection Schedule 2, completely bypasses this entirely. It actually indicates that municipal grievances must go to the municipal council. And at the same time, there's another contradiction in Section 10 that says that the municipal grievances must then go to the municipal manager. So here we've now introducing in this bill a parallel system that actually directly contradicts the system that already applies in local government. And a key part of this structure is it now takes away grievance handling from the officials who actually manage grievances and now hands it over to a municipal council. In fact, councillors are now going to be responsible for processing employee grievances, which is entirely unworkable. Councillors are not managers. They don't supervise staff. They don't meet. They meet infrequently, I think once a month. And they're not equipped, in our view, to handle workplace disputes. I mean, no grievance system in the country places the responsibility for employee grievance on elected officials. And that is what the bill is trying to do, exactly that. So the result is a direct conflict. I think municipalities will now have to be forced to choose whether to follow the grievance procedure, the main collective agreement, which the municipal systems access it must do, or to follow the grievance collect procedure that is in the bill, and the two contradict each other. And I think this is going to be causing massive legal problems and also cause massive chaos. And I think the last thing that you want in local government is have a scenario where employees' grievances are now going unresolved. And also, if all of the employee grievances, if we talk, for example, in a metro that employs between 20 and 30,000 employees, you're saying that all the grievances must go to the municipal council. The ability of that municipal council, which has to deal with a massive other matters, other serious and important matters, to be able to deal with employee grievances, we don't believe that there's a capacity or even time that they have to deal with that matter. And we don't understand why that's a necessity to come in and redesign the system from the ground up that is already working. And that is exactly what the bill was. But there is that, again, as we indicated, the Constitution says that the PSC can investigate grievances. It cannot redesign grievances. So that's where there is an irrational and structurally incoherent aspect to the bill, which is not, in our view, constitutional. And like we've indicated as well, the main confusion we're going to have is that it directly contradicts now with Section 71, subsection 3 of the Municipal Systems Act, which requires municipalities to comply with collective agreement. Next slide. Then one of the main problems that is also a huge issue for the trade unions is that we now have these two grievance routes that are running past side by side. Now it says in section 68A, subsection 3A, and another subsection 2, Roman 2, it says the municipal council must submit the grievance to the PSC. It doesn't say that there's any employee involvement or any employee choice in the matter. So in other words, the employees are now locked into a process that they, number one, didn't ask for, and is now completely outside of the control, which says that the employee grievance is unresolved at municipal level, it must then go to the PSC. So the employee can't decide, listen, no, but I need to go to take the matter to arbitration, or I need to take the matter to the labor court. Now, here's where the danger is. The LRA requires that unfair labor practice disputes must be referred within 90 days of the dispute that arises. And unfair discrimination disposals must be done within 6 months under the Employment Equity Act. So in other words, while this matter has now gone through the internal process and now has to go to the PSC, that 90-day period keeps on running. So what happens with the employee? It now has to sit back and he has to wait for the PSC to finish this grievance process. And if the process is finished and the 90-day period has run out, that employee can find itself time barred by the time it goes to the labor court. I think we're on the next slide already. Yeah, so the employees are effectively locked into that process. And these time periods, as we said, starts from the date of the act or the date of the act that forms the grievance, not from the date when the grievance is finished or when the date that the PSC finished. The problem we are having is that there's not even a choice for the employee. He's locked in that process that he didn't ask for, number one, and he's number two, being forced to go into. So the problem that we have is at trade unions, you might think on paper for the trade unions that it might be a benefit to have that additional process or that additional grievance process, but for us, there's not going to be any assistance if at the end of the day, those decisions are going to be declared unconstitutional because the bill is unconstitutional, and it's not going to have any benefit at the end of the day if the dispute becomes time barred and not because they're incompatible with the time periods of the LRA, and it's not able to ultimately be referred into the LRA. And there's a legislative conflict in the sense that the LRA has a position that says that the LRA overrides any conflicting legislation. Section 210 of the LRA is clear. If there's any kind of conflict, the LRA prevails. So a compulsory PSC process would actually therefore be overridden. Or worse, it can create legal chaos until the court settles it. So we think this is going to be the problem. There's going to be conflict and there's going to be legal challenges for years until the court settles which is the correct process, whether it's collective agreements, whether it's the bill, or whether it's the LRA. And that is the confusion that the bill is causing right now. Next slide. So just as a final point though, the bargaining council, supported by the trade unions, doesn't support further encroachment into the local government as a general principle. And as we indicated, while this grievance avenue may appear to be beneficial on the surface, it's pointless if it's ultimately unconstitutional, because those decisions will simply be set aside. It's going to leave employees worse off. It's going to create expectations ultimately that is not going to be realized. So if the bill nevertheless proceeds, and if the committee believes that the bill should proceed, then at least we need to look at having these grievance systems redesigned in the bill, that they be constitutional and aligned with labor laws and practical for both employer and employees. In our comment document, we did make very specific proposals on how to amend these sections to at least get it in line with the labor relations legislation in this respect. As a final thought, I think I just want to make it one thing clear, honorable members. It is actually exceptionally rare for all three parties, that is SALGA, the employer, and the trade unions, representing 98% of municipal employees, to take a single unified position on an issue of this kind of magnitude. Yet on this, we all stand together. I think both employers and the unions are in agreement that the bill is unconstitutional, that the Commission has no constitutional authority in local government, and that it absolutely cannot rewrite how local government works simply by issuing a bill and effectively almost forcing its way into the system. That is all from our side. Thank you very much, honorable members.
Thank you, Mr. Adams. Indeed, it's a history in making. We hear your representation. Mr. President, are you making any closing remarks?
Maybe clarity, Chair.
Okay, now before we get to that, I was just checking the President as he made his opening remarks, if he wishes to make his closing remarks from their representation. Bamakakula, you covered?
No, I don't think I have any closing remark to make, unless there are questions that members will be able to answer.
Okay, thank you very much. Let me take members for clarities. Remember, honorable members, we are not engaging for now. I'm sure you may be tempted to start engaging, but just seek for clarities. Let me check hands that I have on the screen. You'll start Honorable Kaiser, Honorable Zimande, Honorable Skirkocher, in that order, please.
Hi, Chair. No, greetings, Chair, and to honorable.
I know you. That's why I'm cautioning you.
No, but it's fine, my
Chair,
colleague.
I also raise my hand, please, Chair.
All right, Honorable Peter,
All
you'll
right.
be on the list.
No, you know, municipalities, Chair, already operate under AXA audits, as we know. The MFMA regulations, COCTA oversight, parliamentary interventions, Section 154 and your Section 150, 159, 154 takeovers, and so on. I just want to check, is it the question of the municipal authority and the PSC's jurisdiction that is at play here, which is now suddenly labeled as an encroachment. I'm worried about that wording. Is the real fear perhaps not constitutional interference, but the exposure to entrenched patronage networks that will be oversighted by the PSC. I just want to check that. The second one, Chair, and the last one, of course, Chair, is how does SALGA justify shielding municipalities from PSC oversight when Section 195, subsection 1, makes it explicitly clear that the constitutional values of transparency, accountability, and good human resources management apply to all spheres of government? Why should municipality be the only constitutional space exempted from ethical scrutiny, when we know that municipalities are the epicenter of corruption, irregular appointments, and collapsing services? I just want that because we're coming from an oversight together with you in Madibeng, Chair. Thank you so much.
Thank you. Honorable Nzimande.
The question that I'm asking, as he was talking to the issue of the purpose of the two provisions in the Constitution, do they hold a view that the legislatures could have not thought through that the issue that relates to public administration embraces almost everything, but the latter one, being specific, does not necessarily override what it is intended on the same section, but that deals with a broader aspect? I hear him arguing that no. This has to be read in conjunction with what is specific to public service, which really it's not that clear to me. Thank you.
Thank you very much. Let's take responses on the two members, then we'll take other members after responses. Over to you, colleagues.
Well, thank you very much, Chairperson. I'm hoping that my sound is still clear. Firstly, appreciating the questions coming through from the honorable members. As a starting point to deal with the questions posed by Honorable Ceza, I thought Honorable Ceza's introduction is the answer to his question, in that as we speak, there is already existing mechanisms of oversight through various applications of existing law to try and address some of the weaknesses that have been displayed over time. So the listing by Honorable Ceza is the answer to the question. And so we are asking if there are already these existing mechanisms, plus the fact that it is important that we need to recognize as a principle the existence of local government as a sphere and the related legislation that provides for, in particular, how that sphere is going to address issues pertaining to the administration in particular. Why is there a need to go further than that by providing these provisions, which in our view are clearly encroaching upon the existing legislative prescripts? As it relates to the question directly posed to SALGA.
Sorry,
I can't
Honorable
hear anything,
Molokome,
Chair.
can you mute on your side? Thank you. You can proceed, Mr. Nant.
No, Chair, the direct question posed to SALGA itself around shielding local government. In fact, we're not shielding local government. In fact, as SALGA, we had been at the forefront that there must be accountability and there must be consequence management within the local government space. And we continue to say that there's sufficient legislative prescripts that allows for consequence management and accountability. And we are saying, why do we not explore the application of those mechanisms that exist to address the weaknesses that have been displayed by Honorable Ceza? Chair, Honorable Nzimande, his question seems like it is trying to understand what the PSC is doing through the bill vis-a-vis what we are putting forward as concerns from our side. In the main, our concern is a constitutional concern, firstly. Secondly, is the introduction of the proposed measures that goes against the grain, and there is particular reference to that, creating a role for councillors itself directly in grievance processes. For us, that is problematic. I'm sure, Chair, as a former mayor, you would be well aware about what we have raised over the years is a need for a clear line of division between the administration and the political arm of a municipality. And administrative issues should be dealt with administratively without political interference. And the bill is starting to move towards the latter, which is a concern to us, and the implications that would flow from that. I'm not sure if other colleagues, Chair, I see Craig's hand is up, would add to the response. Thank you very much.
Mr. Lance, Mr. Adams, you can come in.
Thank you very much, Chair. All I wanted to do was just answer Honorable Nzimande's question on the reference to public service versus public administration. So what I was referring to is Section 196 of the Constitution starts as follows. Section 196(4) starts as follows. It says the powers and functions of the Commission are, and then under F, Roman 2, it says to investigate grievances of the employees in the public service. So there's the word public service concerning acts, omissions, and recommend appropriate transfer. So the word public service is what I was referring to in there. Now, there's really, legally speaking, these two concepts, and you even see it in Section 191 as well. The word public service sometimes is used, and the word public administration sometimes is used. Now, these are not simply just interchangeable terminology. They actually have legal definitions, and that was what I was referring to. Now, the first place you would find that definition is in the Public Administration Management Act. It also has that. But the bill in front of you also does the exact same thing. It also has exact same definitions for that. And I'm going to read the definitions from the bill for you for public service and public administration. And that is in Section 1 of the bill. And under there it says public service means A, national departments, B, national government components, C, provincial departments, and D, provincial government components. And then, so that's the definition of public service. So you can clearly see it refers to national departments and provincial departments. Local government is not mentioned at all under the concept of public service in the bill itself. And then the bill goes further and defines what a public administration is. It says a public administration is municipalities and public entities. So I think that's where, and it's the same definition that we have in the public administration management bill. So that's where we have the problem, in the sense that when it comes to grievance authority, the Commission's powers in terms of the Constitution is limited only to the public service, meaning national government and provincial government. And that's the point that we were trying to make in respect of those two definitions. Thank you very much, Chairperson.
Thank you, colleagues, for those responses. The next member is Honorable Skir Koher.
Thank you, Chairperson. I am going to request that you must please protect me from Honorable Ceza, because I'm pretty sure he's got cameras in my office, because he said exactly what I wanted to state, that I don't think that there should be different commission for different spheres of government. So I'm just going to make, because he mentioned what was said in, it's 195 of the Constitution, number 2, where it talks about administration of every sphere of government. That was mentioned, and then also it mentions the administration in every sphere of government. So those principles that goes about public administration. And I hear what they say about the interchangeable, but administration and service. But I also want them to bring them to 196 of the Constitution, which is number 1. There is a single public service commission for the Republic. So if I'm not correct, I just want, that's why I want to, I guess Honorable Kaiser was asking the same one. Why should we exclude a sphere of government that is the one that actually needs this more than any other sphere of government, because that's where most of our corruption is happening. So that's, but I think they tried to answer it, but I just wanted to raise that point again. I don't think they need to respond, because I just feel like this is a bill that will help our administration and public service to actually have it. And I also want to comment and for them to just explain. I think they were talking about there will be 2 parallel systems. But what if the municipal manager is actually the one that needs to be reported? So how do they then resolve that manner? And I think that is where the Public Service Commission enters then, because if you have to report you have to report to the person that you want to report, how do you stay independent? So I just want, how does that resolve it? And then also just a little bit of clarity. I know there's the section 78, 79 managers of the municipalities. They are in the end accountable to council, and council have to then take a step further. I just want, how do we resolve that? But I was mainly covered by Honorable Kaiser, and I just want to reiterate that we need to have this commission, because it really will help public service to be an ethical and capable state. Thank you, Chair.
Thank you. Those cameras must remain because you are always work parallel with Honorable Gaza. So today you are working together. So cameras are effective. Let me take Honorable Peter.
Thank you, Honorable Chair. Chair, mine is to check, Honorable Chair, that because I've got a lot in mind based on the presenter who presented this bill. I just want to check, Chair, based on the information I received from the presenter, who are the experts of checking errors in the bill before the bill be announced? Actually, who are entitled to that? Just for that clarity, before following all due processes. Why, Chair, I'm asking this for clarity. According to my understanding, SALGA is one of the most powerful organs in the spheres of local government. Does SALGA give a fair chance to play a significant role in the Constitution? I just want only that clarity, Chair. I thank you.
Thank you. Our legal team will answer that when we engage with them in the department, Honorable Peter. Let's then take, let me see on my list. Yeah, we've exhausted hands. Let's take responses. Those members who can't raise their hands, please indicate to the chair so that I can accommodate you if you want to make your input. Thank you. Let's take responses on the questions.
Well, thank you very much, Chairperson, and also once more appreciating the inputs. I thought the issues raised by Honorable Skirkogel are very similar to those raised by Honorable Kaiser and were responded to. I thought the issues raised by Honorable Peter, whilst Chair, you did direct around the Parliamentary Legal Services responding to one aspect. There's an aspect that refers to SALGA. Perhaps to clarify on that, it should be indicated, Chair, that where we have a relationship, well, firstly, we agree that we're an active participant in the IGR space, and particularly where we work closely with some departments, including National Treasury and COCTA. There's a very strong working relationship where prior to a bill finding its way into the system, we are consulted on those bills. Of course, we raise our issues. Some of them are factored in, others are not factored in. And it then results in us where we are still unhappy about certain matters. We use our seats within the NCOP, we use our participation in the National Assembly to persuade the legislatures to consider the views that we have indeed raised. We have even gone further, Chair, by even when a bill has been passed by both the National Assembly and the NCOP, and we were still unhappy, we were successful in petitioning the President of the Republic not to assent to those bills because of the sustained constitutional challenges we have raised. Some of the bills have referred back to Parliament for Parliament to reconsider. So it is not a perfect process that by the time a bill is introduced into the parliamentary process, it is unchallengeable, because the evidence before us suggests that in fact it is not the case. And up until the President has assented to a bill, including post the President assenting to a bill, there are still further remedies to challenge, particularly the constitutionality of certain provisions of the bill. So we play an active role. We try as much as possible to influence the bills prior to it getting into the parliamentary processes. If we're unsuccessful, we unfortunately have no option, Chair, but to use these types of platforms to continue to raise our issues. And we are here within the context of that particular difficulty. Thanks, Chair.
Thank you. Any further responses, Mr. Adams?
Thank you very much. I'd maybe just take a stab at answering Honourable Skierkogel's question. I hope I pronounced that correctly. The question was in respect of the municipal managers and where municipal managers are required to submit grievances. Currently, the situation is that municipal managers obviously would have to submit their grievances to municipal council. There can be no doubt about that. And the bill actually does deal with that specifically. And that is dealt with under section 68A, that's in schedule 2, 68 big A, subsection 3, subsection C, and then subsection Roman numeral 1 and 2. It says that a municipal manager may lodge a grievance with 1, the municipal council, or 2, directly with the commission. So there's a special provision that deals with how municipal managers may lodge their grievances, and that obviously we have no problem with whatsoever. And that is the correct way in which it should be done. The problem that we have with is earlier, which is schedule 2, section 68, big A 3, 3A, Roman numeral 1 and 2 again, and that talks about the employer must lodge that grievance with the municipal council or municipal manager. There is where the problem lies. It conflicts with current systems that has a 3-step system that goes up, and where the municipal manager is the end of the system and has no involvement of a municipal council. I'm sure that the honourable member would agree with me that a municipal council, just in general, without me having to go through specifics of this legislation, just as a concept, a municipal council as a office for handling grievances, employee grievances, in especially large municipality where you have tens of thousands of employees, is simply not a workable system, apart from the fact that it is not compatible with the legal system. And like I said, a municipality is going to be struggling with 2 legal problems. Number 1, the Municipal Systems Act, section 71, subsection 73 says you must comply with collective agreements. There is no leeway about it. Now there's a new piece of legislation that says you must follow a grievance procedure that contradicts that collective agreement. And I think that's where the problem is ultimately for us. We absolutely have no problem with the fact that senior managers, municipal managers, have to submit sorry, not senior managers, but municipal managers have to submit the grievances to the municipal council. It is absolutely correct to do, and that is exactly what the bill says. And I think we've indicated what our actual problem there is. Thank you very much, Chairperson.
Thank you very much for those responses. This has brought us to the end of this engagement. We move to the next presenter. Thank you very much to you all colleagues, South African Local Government Bargaining Council, for your representations, which were in details and your responses to the questions. We now we'll skip COSATU, since I've indicated their apology, and they said they'll be covered by what will be presented by the Bargaining Council. We now move to Ms. Makasi, the former DG who represent New South Institute. We have also been with them in many bills that we have processed. Over to you, DG.
Thank you, Chairperson, and good morning to the Chairperson and the honorable members. Could I confirm with the Secretariat whether they are showing the presentation or I should show it myself?
Secretariat, have you granted the right?
You have been given rights to share the presentation. May you please share the presentation?
Thank you.
Okay, thank you. I hope you can see the presentation now. I will just open it up into a presentation format. Sorry, I'm not so good with Zoom. All right. Thank you, Chair, very much. I once more, as introduced, represent the New South Institute, and we appreciate the opportunity to be able to share what our thinking is on the Public Service Amendment Bill. And we just want to highlight a few issues with you that in terms of the NSI mission, I'm sure the portfolio, the committee members are now aware. Ours is to strengthen institutions and build capable and democratic governance. And the PSC Amendment Bill is a pivotal reform supporting professionalization and independence of the public sector, so of the public service. So we take this quite seriously. For us, these amendments are useful in strengthening the PSC's institutional autonomy and professionalizing its leadership, aligning with the long-term vision of a capable and ethical developmental state as outlined in our National Development Plan, and complements very well the Public Service Amendment Bill and the Public Administration Management Bill, the two bills that have been processed through the committee recently, and which have now been approved at the level of Parliament, and we have been informed that they are on the way to the President, or maybe with the President by now. So these three bills are critical in building a professional, capable, and ethical public service in South Africa, anchored in the National Development Plan, as I stated earlier on. This is a key policy and legislative infrastructure that is being put in place, and it includes these bills as well as the professionalization framework, amongst others. There's quite a number of other prescripts and guidelines and guidance, but we just highlight these two as they are quite critical and recent in our view. However, we do want to bring to the attention of the committee that for us, implementation remains a big area of concern. Several policy questions as well need to be further explored alongside to support implementation, and I will highlight a little bit of this earlier on, so that as policy, as legislation goes through, officials and political principles do not rest, because there's a number of policy issues that emerge as we pass this legislation. There are also key risks that confront the professionalization of the state project that requires continuous attention. We'll also highlight a little bit of those. Just in terms of our context, why reform is needed, we're just highlighting our enduring governance crisis as a country, which is characterized by politicized recruitment and interference in administration. This is running across all levels or spheres of government, including the state-owned entities. So it's not in a particular area of governance or of government. weak accountability and widespread corruption, skills deficit, and all these result in poor service delivery as witnessed on a day-to-day basis. And local government occupies a critical role in terms of service delivery. There are some statistics there that we are sharing around some of the critical issues that from a socio-economic stagnation where we are as a country. I will not spend time on them, Chair, but just for information. Also, public trust is quite low in government. It is below 50% in terms of the Afrobarometer 2023. So for us, all these, also the important thing is that there is work that has been done in terms of the Public Service Amendment Bill that introduces clear political and administrative separation, but still requires strong oversight. And I do think that the PSC with its strengthened oversight may play a role in relation to that, a much more effective role in terms of overseeing that implementation as well. Some of the key risks we would like to highlight in terms of professionalizing the SA public sector as a whole, not just public service, but as a whole, include an issue around political will, the absence of sustained commitment from the executive to enforce implementation of the framework and the bills when it conflicts with the political expediency allows reform effort to fail. The same can be said about the absence of sustained commitment from administration, particularly heads of departments, to enforce implementation when it conflicts to what they would want to achieve at a certain time. The second issue is around cadre deployment. I think a lot has been said about cadre deployment on nepotism, but I do want to focus on nepotism because I think that the appointment of officials based on personal or political loyalty at times is more than cadre deployment, but it's really about the nepotism, because if it was cadre deployment, it would be done in a transparent manner that ensure that all the requirements are met. And these undermine the goal of a competitive administration. Higher turnover of executive authorities and HODs. We always talk about higher turnover of HODs, but I can attest that the higher turnover of executive authorities, be it ministers, be it MECs, be it mayors, also has a contributing factor. Having worked in a department where in 5 years I served under 5 different political principals with a turnover of almost 1 year per political principal. So you have to continuously be changing strategy, trying to understand the mood of the political principal and trying to see how you adjust things to accommodate, but also get feedback in terms of those particular issues. From a strategy and planning perspective, it brings a lot of chaos and decision making in the organization. Lack of consequence management, sufficient work has been done on this and a lot has been said. I don't want to spend time except to say that the prevailing culture of impunity means that misconduct is not dealt with consistently and therefore erodes accountability. There is resistance to change, there is non-alignment, there is conflicting and overlapping mandates within the system, and there is lack of coordination, and this creates systemic administrative bottlenecks and result in poor governance and poor service delivery. The last issue I would like to talk about relates to skills deficit, that there is persistent difficulty in attracting and recruiting and retaining highly skilled technical talent needed for effective service delivery. Moving on to what the PSC Amendment Bill does, for us in our view as NSI, it modernizes and strengthens the PSC by ensuring institutional independence through a dedicated budget vote and creating an autonomous Public Service Commission Secretariat. This is an issue that has been raised repeatedly, that the Public Service Commission Secretariat must be independent from government departments, particularly including the DPSA, so that it's also able to exercise oversight over the DPSA without fear and favor. The second area of importance for us is the professionalized leadership, that there will be a merit-based commissioner criteria. Already, it's in the amendments. In any case, NQF level 8 is required with 8 years management experience. We think it's important that there is that baseline that has been set in place so that we do not have commissioners who do not understand how systems function, and yet they are expected to help to contribute in oversighting and ultimately improving systems in the public service. enhanced oversight powers, ability to issue binding legally enforceable directions. We think this is critical for certain offenses that are not given attention, to be able to issue those enforceable directives that are binding, and also that power to summon witnesses and investigate maladministration, because most of the PSC cases delay because of its inability to summon witnesses when they are doing their own investigations. In terms of the expanded mandate, we think that oversight extended to municipalities and public entities does make sense if you look holistically at the functioning of government. And we hear the inputs that have been made, especially by SALGA today, and we do hope that even if it ends up not being a PSC through the constitutional processes that are taking place or will take place, but we wish that there could be a mechanism where there is a much more joined up working together and supporting each other through some form of legal instruments that are going to commit the different parties if it was not to be in the legislation. In the fourth area we move into is advancing a capable ethical development state, and we just want to highlight a little bit of rationale why we support this bill and recommend adoption. And I've already indicated about the strengthening of the PSC, the Secretariat and Professionalized Commissioner, the Independent Budget Board, the binding powers, and the issue of municipal powers, which we hope that would contribute in addressing chronic weaknesses within the municipalities by doing robust investigations and oversight in that context. Then moving on to the key policy questions, we do want just to park these to the committee can see what to do with them in the future, but we think that it's important that we think about these key policy questions that affect the entirety of the professionalization, including particular this bill. The first one is around what specific safeguards are required to prevent political interference in the process of appointing, suspending, or dismissing public service commissioners. How will their professional competence be ensured? Because we shouldn't assume that by virtue of somebody raising their hand as a commissioner, they are ethical, they have integrity, they have all these things, and they are competent to do their work. And how will their impact in building a professional and ethical public service be measured? What type of performance contracts, what type of citizen-driven or even departments-driven that they are supporting kind of impact and feedback that would be put in place. The second one is, to what extent should the PSC's findings and recommendations, particularly those concerning ethical violations or non-compliance, be legally binding versus advisory to enhance public accountability and impact? How will the extended PSC mandate be clearly distinguished from the functions of the oversight bodies, such as the Auditor General, Public Protector, to avoid unnecessary overlap, duplication, and conflict? What governance mechanisms, dedicated funding model, allocation of skills personnel, and technical resources are necessary to enable the PSC to effectively extend its oversight mandate to all municipalities and public entities? How will the policy and legal framework for PSC oversight over municipality be designed to legally reconcile and respect the constitutional principle of local government autonomy? Again, SALGA has expressed in detail what that autonomy means in local government. What enforcement and tracking mechanisms will be established to ensure executive authorities swiftly and consistently implement the PSC's findings, recommendations, and directives, thereby closing the historical implementation gap? Currently, you have the PSC experiences a lot of gatekeeping from political principals and administrators in terms of implementation of their findings, and they have nothing else to do except to keep on writing and threatening to go to court. How will the legal force of the PNC be enhanced in practice to ensure immediate impact, considering that administrative decisions are currently reviewed through overburdened judicial system and take long? Perhaps an idea of some form of a court that would look at these matters so that we know if there's a matter at the PSC within a short period of time, there's an outcome and there's action that is taken in respect to those issues. That also relates to their capacity in terms of personnel. In conclusion, we want to highlight that the PSC Amendment Bill is an essential piece of the puzzle to ensure the administrative reforms are actionable. It provides the enforcement power needed to professionalize the state and rebuild public trust. The NSI views the processing of the bill as a critical step towards a capable, ethical, and developmental state. However, concerns exist regarding the political will, the administrative will as well, and operational capacity to drive implementation of this bill. The ones that have recently been approved, and the professionalization framework, especially in the context where you may have people at the political level and at administrative level with the responsibility of driving these processes, but who may not agree with these processes that they are driving. Perhaps the committee could, in its subsequent sittings before the end of the financial year, invite these key institutions to bring back an integrated implementation roadmap to drive impactful implementation. On that note, Chair, we would like to thank you on the committee on behalf of the New South Institute, and further assure the committee of our support in ensuring that these processes are taken to the conclusion and there is effective implementation that is impactful to changing the public service. Thank you very much.
Thank you very much, Ms. Makasi, for your detailed representation. We are now going to call upon members if there are clarities that they seek from you. Members, is there any indication of such interest to get clarity? I don't see. Okay, there's only one hand. Honorable Chaza.
Thank you, Chair. Very progressive. Thank you very much, Mbogoto. A clarity of thought, well-researched, factual evidence, statistic, data, lived experiences. And I think, Chair, in future, what we should do, those questions, the policy questions, we should ask the department and the legal service to kind of capture those questions for us and interrogate them. That's my parting shot. Thank you very much, Chair.
Thank you. Thank you very much. We now move to the next presenter. Thank you, Mr. Elisha Makasi, for your presentation. We move, and you've been with us on the other bills that you have processed. We now move to Dr. Charmaine Gilbert, who will represent Public Affairs Research Institute and the Ethics Institute. Over to you, Doc.
Thank you very much. Good morning, Chair, and good morning, honourable members. Can you hear me properly? I'm just checking that my microphone is working.
You are
Great.
audible.
Okay, I'm going to share my presentation. So the presentation today is a joint one for the Public Affairs Research Institute and the Ethics Institute. I don't know whether you can see the screen yet. Just putting it on full screen mode. Okay, can you see?
It's perfect. Yes, thank
Great.
you.
Okay. So just to reiterate that it's a joint presentation for the Public Affairs Research Institute, the Ethics Institute, the Equality Collective, and PSAM, Public Service Accountability Monitor. More information about, sorry, just going back to the beginning of the presentation. There. Okay. We've presented on the bill a number of times, and we want to, similar to the previous speaker, to reiterate our support for the bill. We think it's important to give effect to the policy direction that has been signalled by government for a long time. So here we're talking about the National Development Plan and more recently the Professionalisation Framework, which was adopted by Cabinet in 2022. And we recognise a series of other kinds of policy steps that have been initiated over the last few years, including, importantly, amendments to the Public Service Act and to the Public Administration Management Act. Choose to do that, and I'll come back to that point later. I wonder if maybe before I get through to the rest of the presentation, we didn't spend much time in our presentation talking about the question of the constitutionality of the bill in regard to extending the mandate to local government. And I logged on to hear some of the conversation and presentation from Lance Joel for Salga and other colleagues. We didn't comment on it. We are supportive of that move, but we do note that there are some concerns, and I think the question of whether it is constitutional or not is somewhat open to debate. So I think if you look at the way Section 196 1 and 2 is framed, one could read a potential role for the Public Service Commission for the public administration more broadly. If you read Section 196 4 in detail, it suggests maybe not. And then, of course, there's always the perennial question about how to interpret the Constitution's provisions in 151 around the autonomy of local government. So our sense is that it's open for discussion and debate and interpretation of the Constitution, and that is obviously an important social and political process. We feel that there are grounds for seeing that role for the Public Service Commission for the whole of the public administration, and we support that view for reasons that the previous speaker outlined. And we feel that, we do feel there is some need for a central body to support processes like checks and balances and recruitment processes, not usurping the prerogative of council to appoint, never usurping that, but to support it, to make sure that that process is safeguarded, that it has integrity, that people who are well qualified and appropriately qualified and committed to the development agenda of local government make it onto that selection process and could be supported by a body like the Public Service Commission to do that. And then, of course, if it isn't the Public Service Commission, are we going to be setting up another body or etc.? Some people have mooted provincial decogs. I think the Public Service Commission is the best place to play that role. But I think it obviously it needs further discussion with organised local government. But we are very, very much in support of that move and building up the capacity of the Public Service Commission over time to play that role. With that in mind, our first minor comment is that the bill defines the public administration as including the public service, and it's not clear to us why the application of the Act in Section 2 doesn't simply read as applicable to the public administration. So we can see a reluctance to let go of this word public service. If we are defining public administration as covering both public service and public entities and local government, then I suggest we start to use that kind of language. And sort of, how can I say, back the policy move fully. On the question of appointments, so I just wanted to say that one of the reasons we're so supportive of this bill is that it strengthens the independence of the Public Service Commission. And given that the bill now gives the Public Service Commission greater authority, the question of independence becomes so much more important. And the question of the Public Service Commission's independence is also really important, given a potential role as envisioned by the professionalization framework and the NDP for the PSC to support enhanced recruitment processes towards meritocratic appointments. So we're very pleased to see that this bill does that. On the particular matter of the appointment and remunerative work for the commissions, we welcome Section 4, which outlines the process and standards for appointing commissioners. And we don't really have any particular comments here, just, I suppose, since we are in Parliament, to enjoin Parliament to ensure the development of an appropriate process for recommendation of fit and proper persons to the position, that Parliament can assist in enhancing the prominence and standing and trust of the Commission in the eyes of the public. Clause 6, which refers to remunerative work by the commissioners, we are concerned that making the president responsible for authorizing such work, and we do think that there might be occasions where such work might come up, but we are concerned that making the president responsible for authorizing that provides a kind of political leverage of the president over what should be constituted as politically independent positions, the commissioner. And we feel that it would be better that the commissioners are not beholden to the president in that way, as this undercuts Public Service Commission independence. And we suggest that rather than that relying on a decision by the president, this should rest with a standing subcommittee of the Public Service Commission itself, guided by clear and transparent policy. This is how, good corporate governance manages these kinds of issues internationally. But we do think that if you are beholden to the president for questions like this, it can potentially undercut independence. And while at the moment we have a president who I don't think would do that, and commissioners who would not do that, one has to build a system that anticipates people with, other motives. Questions of public access. Section 12 says to support mandatory disclosure of the Commission reports, that in the public interest, we propose that there's an additional paragraph inserted. The Commission must properly release on its website all finalized reports that reveal evidence of substantial contravention or etc. That relate to potential public harm. So essentially, we're arguing for slightly more transparency to be inserted into this provision. We understand that there may be reasons that not everything could be made public, but we're setting out a clear criteria which would help decide when the interest of the public overrides other considerations. Implementation of decisions of the Commission. Section 13 reads, in the event of a refusal or failure by the executive to report as provided in that subsection, the Commission may report that refusal or failure. And we are saying we would rather see it made a requirement that that is reported, so to strengthen that provision. This is a really important issue, the appointment of the CEO of the new secretariat. The bill, as the previous speaker noted, the bill is particularly important because it strengthens the Public Service Commission's independence by creating a dedicated secretariat that sits under the Public Service Commission instead of under the DPSA. So this is a really important move. When we made our submission to Parliament last time, we said that as the bill stood at the moment, the fact that the bill didn't cater for moving the appointment of the CEO under the direct authority of the Public Service Commission was an issue. And we've noticed that the bill has been changed in this regard, and we commend Parliament in taking seriously previous comment to the bill and making these changes. So our sense is that that change from I think it's A version to the B version now, we think is a very good one, and we're very supportive of it. As a result of that change, we see the need for further minor adjustments to other pieces of legislation, specifically to the public service regulations, which then need to be changed in order to tie in with the B version of the bill as it stands now. In the Public Service Commission Public Service Regulations, Section 67(2)(c) provides for the appointment process for the head of the office of the OPSC. So it just needs consequential amendments in other regulations. We think it's really important that even though this is a minor issue, it is attended to, so there's no ambiguity. And then we also argue for a very robust selection process to be elaborated for the CEO, in order, again, to further bolster the independence and the stature of the PSC and to ensure continued trust in that secretariat in its support to the Commission. And we propose drafting language that could outline what that process might look like. I can go through the details if you wish, but it's essentially just to strengthen the integrity of the selection process for that CEO. This is a minor issue and we just noticed that in Section 20, it seems that the where Section 20 is written, it only caters for the cases of the public service. And we have suggested that it's amended slightly to ensure that this caters also for the public administration. Yeah, so I don't know whether we're reading correctly, but our suggestion is this could be easily amended by simply inserting the drafting notes to cover the broader public administration in. And so this is our final and I think most substantive point. I said at the beginning of the presentation, we felt that the bill, which we welcome, has this big omission that it doesn't explicitly provide for a role for the Public Service Commission to play in safeguarding senior appointment processes. As mentioned, this is very clearly outlined in the National Development Plan as something that they would like the PSC to play. The professionalization framework also moots it in 2022, and it is a role that many public service commissions around the world do play. The idea is not that the Public Service Commission is appointing in any way, but that it has a strong role in safeguarding the selection processes for DGs, potentially DDGs, and heads of department at the provincial level. And we would like to also see the Public Service Commission play a role in supporting selection processes at a municipal level. So again, not usurping the political role to appoint, but ensuring that a really robust selection processes support good appointment by council or by the president in the case of the DGs. This is not catered for in this bill. It's not catered for in the Public Service Amendment Bill, and obviously Parliament doesn't cover that. So it's currently still a lacuna. The state has made great claims in policy visions and policy proposals that it's going to attend to this matter, but it keeps, how can we put it, maybe standing back from finally addressing this very thorny and difficult issue. But it strikes us that if, we take the State Capture Commission as evidence, some of the honourable members were talking about the extent to which local government is a site of major patronage. This question of robust appointment processes for senior personnel is the burning issue for addressing corruption. And we have proposed that we think that there's room for the Public Service Commission to play a strong role in supporting that process through assisting with, for example, the professionalization framework suggests they hold a database of experts who can support recruitment. We would like to see them playing a role in actually setting up the panels for DGs, etc. Again, they're not doing the appointing, but they are supporting a robust process. And then what we do is that we actually provide text that could be used that could be inserted into the bill to address this. And again, the way we've crafted the text, it says here, the Commission may facilitate and administer recruitment and selection of candidates for the public administration after application by the authority responsible for appointment, and it must facilitate and administer recruitment and selection for the public administration to the extent required by any other law. The way we've suggested or crafted this proposed clause is that it leaves open precisely how that might be done by the state. It leaves open the fact that, for example, there may be decisions that the head of the public administration might be involved if we end up setting up that office. So it doesn't foreclose the direction that this reform might take, but it creates essentially an enabling clause that the state could then use when it is ready to move in that direction, as it has been suggesting for something like 12, 13 years now. I'm going to end there. Thank you very much. And our details are here.
Thank you very much, Dr. Gilbert, for your detailed representation. Honourable members, it's now your turn if there are clarities that you seek from the presenters. Please indicate. I will count 1, 2, 3. 1, 2, 3, no hands. Thank you very much. We now move to the next presenter. Thank you, Doc. The next presenter will be Mr. Bradley Swanepoel, representing Commission for Gender Equality. The podium is yours. You can take us through your representation. Over to you.
Right, thank you, Chairperson. Can I just confirm you can hear me?
Yes, we can hear you, and you've been granted the right to present.
Right. Thank you. Let me just get my presentation up. All right, my presentation should be showing. Can you see it, Chairperson?
Yes, you can see it. You can put it in the PowerPoint presentation slides.
Right. All right.
Thank you.
Thank you. All right. So good morning, Chairperson, and good morning to honourable members. My name is Bradley Swanepoel. I'm a legal researcher at the Commission for Gender Equality. First of all, thank you for the invitation to present to you today, as well as the opportunity to do so. In my presentation, I'm going to very briefly take you through the mandate of the CGE from a constitutional perspective, and then our mandate in terms of our governing legislation. And then I'll briefly go through the points we made in our submissions that have a previous submission that have been incorporated into the bill but might need some tweaking. And then I will go on to taking you through the submissions that we had made but have not been incorporated into the bill, and which we would like to be reconsidered. And then I will conclude. All right, as far as the mandate of the CGE is concerned, we are one of the 6 Chapter 9 institutions created by Section 181 of the Constitution, specifically Section 181 1D. And then in terms of Section 187 of the Constitution, our constitutional mandate is to promote respect for gender equality and to protect, develop, and attain gender equality. Then 187.3 of the Constitution provides that the legislature may ascribe to us or prescribe to us any additional powers in legislative form. And that has been done in the Commission for Gender Equality Act, and more specifically Section 11 of that Act, which sets out a whole host of the powers that we have, but the ones that are relevant to this particular submission today are the power to monitor and evaluate policies and practices of entities, both in the private and public sector, the power to evaluate any law proposed by Parliament affecting or likely to affect gender equality or the status of women, and the power to make any recommendation that we deem to be necessary. Okay. So in February 2024, the CGE had made previous submissions on the bill, and we were pleased to see that some of these submissions that we made have been now incorporated into the bill. So these included submissions we made regarding continuity of the commissioner's terms. And we'd made that submission because we felt that there should be an avoidance of any kind of vacuum of leadership and loss of institutional memory by the Commission. However, we did note that there in the current bill, there's no provision to provide for staggered terms in the event that multiple commissioners' terms expire at one time. In our previous submission, we'd also spoken about affirmation of professionalization and ethical standards and appointment criteria for commissioners. And we were pleased to see that the bill does in fact support the professional ethos of the public service. And although it's not legislated in the bill, we were pleased to see in the explanatory memorandum support for integrity assessments and entry examinations in line with the comments by the State Capture Commission. Then we'd made submissions on PSC independence, and although this is set out in the Constitution, we felt it was important that it be reiterated in the bill as well. And we had made submissions on the use of gender-neutral language, and we were pleased to see that the bill in its current form, for the most part, avoids defaulting to masculine nouns and pronouns like chairman, and instead uses terminology such as chairpersons. So we were happy about that. Okay, then in regard to the submissions that we'd made that we were not incorporated in the bill and that we would like to still argue for, the first relates to the composition and the size of the commission. So I believe the bill provides for 14 commissioners, and our submission argued that this might be too many and might because of the size, undermine the efficiency, the responsiveness, and streamlined decision-making of the commission, and that it might be perhaps more prudent to reduce the number and then allow for more sort of appropriate skilled commissioners in the process. We made a submission that perhaps the bill should include gender provisions related to gender oversight and monitoring. And this was because issues of poor public service delivery, particularly when it comes to corruption, these disproportionately affect women and girls, particularly when it comes to services such as health, education, provision of water. And so we would recommend that the bill include powers of the PSC to monitor and evaluate the gendered impact of a lot of service delivery that is delivered by different levels of government. We'd made a submission regarding clarification on functional independence of the commission. We were of the view that although the commission provides that the Constitution provides that the commission is an independent body, we felt that the bill provides provisions for insufficient freedom from political interference in the actual implementation of its programs. And then finally, in regard to ethical public service and gender equality considerations, again, because of the point I made earlier that poor service delivery disproportionately affects women and girls, we felt there should be some kind of acknowledgement of this in the bill, but that hasn't been done. In conclusion, therefore, Chairperson, the CGE supports the overall intent of the amendment bill, which is to strengthen institutional independence and professionalism. We're very, very happy to see that a lot of our previous submissions have now been included. But we feel that to fully realize a truly transformative and gender responsive public service, there perhaps needs to be a little more further refinement to the bill on the issues that I have already set out. And we trust that the submissions that I've made today will be considered in the pursuit of a capable, ethical, and inclusive public administration. And that concludes my presentation. Thank you very much, Chairperson.
For your representation, you were within time, but you presented your detailed, you have made your detailed representation. Honourable members, are there any interest of seeking clarities?
Just one, Chair.
Yes, Honourable Chaza, I hope that you have switched off your cameras where Dr. Skir Kocher is located.
They are off, Chair. No, Chair, I just wanted to check with the Commission for Gender Equality whether they feel like there is an encroachment by the PSC on their constitutional mandates in light of the fact that SALCAS raised the encroachment word. I just wanted to check within your section 81 as a Chapter 9 institution, whether you feel like this bill does contribute towards an encroachment by the PSC into your own powers, because there are powers, your powers, there are powers of the AG, there are powers of other Chapter 9 institutions that are already at play. And in terms of the enforcement and the teeth to bite for those institutions, do you think that the PSC perhaps the PSC bill will actually contribute to the extrication, to free and to disabuse the local government and to disabuse the public service and administration of chronism and corruption. Thank you very much.
Thank you, Honorable Chaza. I see Honorable Peter as well. You can come in, Honorable Peter.
Thank you, Chair. Mine is to just take, Honorable Chair, from Honorable Swanepoel, that is this his first appearance to submit his submissions to the PSC, or his appearance is on an ongoing process from the previous administration? Or if so, does he see his submission appeared on the bill? I just checked that. Thank you.
Thank you. Mr. Swanepoel.
Yeah, thank you, Chairperson. So in regard to the first question about whether we feel there's encroachment, the short answer is no. The Chapter 9 institutions, particularly ourselves, and well, I know also the Human Rights Commission, there was a point raised about enforcement. The Human Rights Commission is currently litigating before the Constitutional Court in regards to the issue of the legally binding nature of our recommendations. The courts have so far said that the recommendations of the Human Rights Commission and that would apply by extension to the CGE are not legally binding, because the purpose of Chapter 9 institutions such as ourselves is to get justice, not administer it itself. In other words, we are supposed to facilitate the attainment of justice rather than actually issue it. And for that reason, our recommendations are not binding. We have to have them enforced by a court of law. So no, we don't feel that there's an encroachment on our mandate. I think it must be reiterated, our mandate is specifically intended to deal with gender issues, and obviously there are issues that might arise in the PSC that do not touch on that issue. In regard to the second question about whether or not this is my first appearance, yes, it is. We did make a submission, as I said, in February 2024. But this is my first time appearing before the committee to speak on these submissions. So I think that concludes the two questions, Chairperson. Thank you.
Thank you very much for the responses. Members, if there are no further clarities, we can then conclude. This has brought us to an end of our engagement in processing the inputs from all stakeholders. On behalf of the collective leadership of this committee, we wish to express our sincere gratitude to all of you colleagues for having displayed a high level of dedication and commitment and professionalism in how you have formulated your representations, to the kind of research that you have conducted. It shows that all of you gave enough time to yourselves to research on these items, and we appreciate the level of insight you have displayed on the subject matter. And we want to guarantee you that as a committee, broadly speaking, we are a maturing democracy in the Republic of South Africa. And our constitution is the supreme law of the country. There is no law or any legislation that can be passed if that legislation contradicts the constitution of the Republic of South Africa. So therefore, even our legal teams, when we engage early next year, they will be presenting in relation to what we have raised as issues pertaining to the Constitution and all three spheres of government. But of course, taking into cognizance that we are also mandated as the NCOP to deal with the corporate governance, which relates to intergovernmental relations of the three spheres. And there are new dimensions. DDM forms part of that, which brings all three spheres of government together to work together with one common objective to service our communities. So all that being taken into cognizance, and we have received warmly all your representations, and there is nowhere where you suggest the total throwing away of a baby with the bathwater, but you are saying there are considerations that must be looked at when this legislation is being processed. So we give that commitment on behalf of the committee, and will ascertain that you receive from the department their responses on detailed response on each and every issue that you have raised with us. So with that, we wish to thank you and wish you great safety holidays. Those who celebrate Christmas, we wish them a Merry Christmas and a prosperous New Year to all of us with our families. May we all be safe on the roads. We are also keeping the families of those who are affected by floods in our prayers during this festive season. They will be having difficulties of enjoying Christmas like all other people in the country, but we'll keep them in our prayers, and we'll also pay oversight that municipalities and the Department of Cooperative Human Settlement, they are indeed on board to try and support those communities. But all of us, we must take responsibility in our behavior and ensure that we don't drink and drive. We can only drink water and drive, because juices and other stuff, they don't assist in your eyesight. So water is recommended, especially when you are driving long distances. But let us share with those who do not have anything. Your neighbors, those who are attending churches with them, the communities in general. Let us really embrace that unity that deserves to be appreciated during this period. So we wish you everything of the best, and we'll get a response on how we have processed this Section 75 bill, but we wish to commit that we'll speedily conclude this at the beginning of the year, since we have come to an end of this year. All the best to you all and the organizations. May they be continue growing as we'll continue interacting with you as the Select Committee. We really appreciate your presence. You can take leave. We are going to remain as a committee to process our internal matters. But thank you very much once again for your presence and your representations. This session is now closed. Have nice holidays. Thank you. Honorable members, as they are taking leave, we are now going to be dealing with the report that we need to process. And that report, we wish to apologize, because when I checked early in the morning whether all members have received the report, Mr. Manuel did indicate that he attempted to post the report. We don't know what happened to his gadget. The report could not reach members on time. We wish to apologize in advance for that happening, and for that mishap. And we are going to be now allowing you. I table the report, and Mr. Manelo just take us through the observations and the recommendations, and the whole body of the report is there in what has been forwarded to you. Okay, Mr. Manele.
Thank you very much,
Over to you,
Chairperson.
sir.
Thank you very much, Chairperson. Honorable members, as the Chair has indicated my sincere apology. I had a technical system problem. Chair, with your permission, we are dealing now with observation, Chair. We have plus minus 18 observation. I'm not going to read them paragraph by paragraph, but I will just emphasize the meat, each and every paragraph, Chair. 19.1, Chair, is just an emphasis that the forensic investigation followed a tip-off by whistleblower alleging corruption, fraud in the municipality. The tip-off also implicated senior officials and some councillors in violation of the Code of Conduct and Supply Chain Management Policies, Chair. 19.2, Chair, is just a context to say the forensic investigation started in December 2017. During the early stages of the investigation, investigators identified additional serious issues of maladministration, mismanagement that warranted further investigation, Chair. The committee has also noted that the allegation included conflict of interest and municipal officials and councillors who failed to declare their business interest, which contravenes the Code of Conduct and Supply Chain Management Policies. There was also a matter of dishonesty regarding the appointment of an official who had been dismissed from other municipality in Eastern Cape for misconduct, Chair. 19.4 is just an observation that in July 2018, the Western Cape Minister of Local Government, Environmental Affairs and Development Planning designated external investigators to conduct investigation in the local municipality in terms of Section 106 of the Local Government Municipal System Act. 19.5 is an observation that the committee has noted investigators concluded the investigation in March 2019, and the forensic investigation report with findings and recommendations was provided to the MEC of Local Government, Environmental Affairs and Development Planning. 16.6, Chair, is just an emphasis. Members will recall that during the engagement of the department, the Chief Whip asked constitutional and procedural questions as to whether the report was tabled to the NCOP. And in terms of collaboration with the Secretariat and the NCOP Chair, there's an evidence that during the 6th administration, meaning on the 18th of February 2020, the report was then referred to the Select Committee by the then Chairperson of the National Council of Provinces, Chair. And with regard to our parliamentary referral system, there's an evidence that the Chairperson of the NCOP referred on 3rd March 2020, the forensic investigation report to the then Select Committee on COCTA for consideration and reporting. And in terms of reporting, Chair, and the document that is before the House, the current Select Committee is procedurally obligated to report to the NCOP with regard to this report, Chair. Let's go down, Hypo. 19.8, honorable members, it's just an emphasis to say the investigation report that was tabled to the MEC of the Local Government, Environmental Affairs and Development Planning have made some couple of recommendations, Chair, which are in summary 4 of them. 1, disciplinary action be taken against certain municipal employees and councillors for their non-compliance with municipal policies, the municipal, in terms of Municipal Finance Management Act and the respective codes of conduct for councillors and for municipal staff members. Number 2, criminal action of suspected corruption, fraud, and racketeering to be instituted by the South African Police Services against implicated officials and organizations. Number 3, the municipality to address certain expenses being incurred by pledged tourism in contravention of their memorandum of agreement with the municipality. such as food and entertainment expenses paid out of the events attended by the municipal officials, councillors, and their families. Last one, the municipality to address, can you go a little bit up? Thank you. The municipality to address the undue and unlawful influence of certain councillors over the recruitment and selection processes at the municipality. 19.9, in terms of the opening of criminal cases, the Select Committee has noted that the Department of Local Government, Environmental Affairs and Development Planning has reported possible criminal conduct was reported to the South African Police Services with case numbers case 14/4/2018 and the second one 42/09/2018, but to date, both matters are still under investigation. In terms of the civil action, the committee has noted that the department has referred the recommendation regarding civil recovery to the Municipality Council in terms of Regulation 3 and 4 of the Municipal Regulation on Financial Misconduct Procedures and Criminal Proceedings. 19.11, in terms of disciplinary action, the Select Committee has also noted that the department has referred recommendation to discipline those officials implicated in the report to Bhutto Local Municipality for further internal action. The other one, which is very important on our members, which we'll see when we are dealing with recommendation, is 19.12. In terms of referrals, the Select Committee has also noted that the findings and recommendations were referred to the Auditor General of South Africa to ensure compliance assessment with regard to the findings and recommendation. 19.13, despite the progress made, the Select Committee has noted with concerns the slow process of investigation, disciplinary processes, consequence management on the triggers leading to findings and recommendations emanating from the forensic investigation report. Next page, please. Next page, April.
Is it freezed?
Apparently, Chair, I will read from my phone, Chair.
Can we get an indication from her as well?
Hypo, is it freeze? Okay, 19.14, honorable members, I'm sorry about that. The Select Committee has also noted with great concerns that the findings and recommendations of forensic investigation have not yet yielded the positive results of financial losses being recovered, prevented, or are in the process of being recovered. Consequence being implemented, meaning consequence management being implemented for the official responsible through disciplinary processes and where applicable, fraud, criminal investigation being completed by relevant authorities. This one refers specifically to the South African Police Services. 19.15, the committee has also observed during engagement that the senior departmental officials could not respond to questions related to dates related to notification to NCOP, reasons for delays on the processing of referral criminal cases for investigation by SAPS, disciplinary actions by the municipality, and referral to the Auditor General of South Africa. Will correct the proposition there, Chair, not to say by, but to say to. 19.16, the Select Committee has noted that the department moved to lay charges with the police and refer the matters to AGC. This one is just an emphasis, but it's a repetition. We'll deal with that one on Chairperson. The Select Committee has also noted with concerns the absence of early warning systems and weak internal controls to prevent incidents of fraud and corruption. Next page. 19.17, the Select Committee has also noted that the final investigation report was provided to the MEC, and the next step taken were that 1, correspondence was prepared for signature by the MEC with supporting documentation. In respect of phase 3, in which it was recommended that the municipality should commence with legal action against Vuyokazi Mbelani to terminate her contract of employment with the municipality. 19.18, the Select Committee has also noted that the affidavits were prepared for the purpose of reporting suspected criminal actions to the SAPS. Recommendation to the MEC were prepared to assist him with assessing the seriousness of the situation and the municipality response thereto. Number 2, determining whether the situation justifies or requires intervention in terms of Section 139 of the Constitution. 3, determining whether the situation requires steps to be taken to monitor and support the municipality or to promote development of municipalities' capacity to enable it to perform its function, as the case may be. Number 4, if satisfied that the municipality cannot fulfill a statutory obligation as a result of incapacity, determining appropriate steps in cooperation with the municipality to develop municipal capacity and to ensure that the municipality implements applicable practice notes and other best practice standards. Next page. This one, all members deals with recommendation. Just to say, based on the observation that I've made there, the recommendation has been crafted in a manner that there's an element of executive accountability and parliamentary oversight. 1, in respect of the SAPS, 2, the National Prosecution Authority, 3, Special Investigation Unit, and the Auditor General. Let me read them in terms of sequence, honorable members, with your permission. 20.1, having considered the report on forensic investigation conducted in terms of Section 106 of the Local Government Municipal System Act, the committee recommends to NCOP as follows: that the NCOP notes the findings and recommendation of the report on forensic investigation conducted in terms of Section 106 of the Local Government Municipal System Act in Bito Local Municipality. 20.1.2, that the Department of Local Government, Environmental Affairs and Development Planning, the District Municipality, the South African Local Government Association, and the Bito Local Municipality should, in the spirit of cooperative governance and intergovernmental relation, ensure the implementation of the findings and recommendations emanating from the forensic investigation. 20.1.3, that the executive mayor of the local municipality should, after 21 days that the NCOP has approved this report, provide the Select Committee, meaning our committee, with progress report on the outcomes of disciplinary processes. We focus on consequence management, financial recovery, improvement of internal control systems, and action to deal with the findings and implementation emanating from the forensic investigation report. 20.1.4, that the Western Cape South African Police Services should, after 21 days that the NCOP has adopted this report, provide the Select Committee with progress report on case numbers as indicated in the observation related to investigation in terms of Section 106 in the municipality. 20.1.5, that the Office of the AG should, after 21 days, the NCOP has adopted the report, provide the Select Committee with progress report on the findings and recommendations referred by the Department of Local Government, Environmental Affairs and Development Planning for consideration and compliance assessment undertaking at the municipality in terms of the requirement of Section 106 of Local Government System Act. 20.1.6, that the Select Committee jointly with the relevant portfolio committee in Western Cape Provincial Legislature conduct during the 2026 parliamentary first term post Section 106 forensic investigation impact assessment in Pito local municipality. Next page. That the select committee should, during the oversight visit to Pito local municipality, facilitate interaction with the internal and external stakeholders, including one, the Department of Local Government, Environmental Affairs and Development Planning, chief whips of political parties, South African Local Government Association, Organized Labor, South African Police, Auditor General of South Africa, Special Investigation Unit, National Prosecution Authority, business, youth, disability forums, to solicit their opinions on the implementation of the findings and recommendations emanating from the forensic investigation report. 20.1.8, that the Department of Local Government, Environmental Affairs, Development Planning should, together with SALGA, provide support specifically to the local municipality generally, specifically, and generally to other local municipalities. Can you just go down, Hypo? Generally to municipalities to put in place early warning systems to avoid recurrence of incidents of fraud, corruption, and the recruitment of people with dark clouds. The last one, the select committee is now calling upon all the role players in Buto local municipality accountability ecosystem to support, monitor, and oversee the implementation of the recommendations emanating from forensic investigation in a drive towards achieving wholesale good governance and service delivery. Chairperson, thank you very much for the opportunity given.
Thank you, Mr. Manele, for saving my voice so that when I'm required to go to the NCOP and present this report, at least I'll still remain with a voice since you have covered the report adequately. And thank you for also being the initiator, author of the report on our behalf. You have done a sterling job. Thank you very much. Honorable members, here is the report presented before you. Now let me take your comments in the report before we adopt the report. Honorable Skirkocher, we are number 1, followed by Honorable Zimande, followed by Honorable Berenhorst, followed by Honorable Eza. Any other member? I'm closing. There will be no second round. I'm taking one round. Honorable Mabibo, we can see you. Our Honorable Whip always have a challenge of raising a hand, and I think she has disappeared on the system. But let's take those hands. Honorable Peter, you are the last one. Let's take Honorable Igor, followed by Honorable Zimande.
Thank you, Chairperson. Hippo, can you just scroll to 20.1.2, please? Chairperson, just on this, that the NSQRS should ensure implementation and findings recommendations. I feel that with this thing, it's very much ambiguous, and I feel like we need to give them a time frame, either within, let's say, the first term of 2026 or after we visit. So I don't, because I see there's a lot of 21 days. So I don't know if we could do that in line with that or give them a time frame, because otherwise, if we just say that ensure the implementation of the findings recommendations, we're going to sit another 9-8 years, because this was resolved. That started in 2017 already, and it's only being finalized now. So I feel like we need to also add a 21 days or something that's within a reasonable time. Then Chairperson, Hippo, 20.1.7. Then this one I also added that we need to have a time frame that we could possibly, for us, it says should during our oversight visit to Bitom local municipality, I would want us to possibly put in here that we also put that into our first term of next year, because I don't want us to face the challenge that we had with Nala municipality, where we received the report earlier in the year and we went later in that year, and then we saw the problems that they have.
Yes, Yebo, whip on the lobby.
Oh, okay.
Let's accept the whip. Yes, thank you.
Chairperson,
You
you're
can
not
proceed.
Okay. All right. So I just think that we need to in 21/7 put also when are we going there, so that we have a clear timeline. So because while it's fresh in our mind, so when we get there, it's not a repeat of what we have done. And then 21/8, just scroll up for me, Ipo, for 21/8. Can we scroll up? 21/8. Because I need that last part.
Put it a little bit up so that we can look at it in totality. Dr. Mtimkulu, 20.18. Bring it up. Is the system freezed?
Yeah.
Okay. Maybe if they reboot, it's gonna be better.
Oh, there we go. All right. Thank you, Chairperson. On this specific one, it said the last part, and generally to municipalities, the Department of Local Government, Environment Affairs Planning should, together with SALGA, provide support specific to Bitom municipality and Journey municipality to in place early warning systems. I think with this thing, I think we need to be specific that, and also again give Bitom municipality a time frame to report to us what early warning systems that they have in place. The reason why I'm requesting that is not that we are telling them intruding in their space, but it's just for us as a committee to see what are the measures and the mechanisms they have implemented, and then when we do have our oversight there next year, have they worked? Are they sustainable, so that when we have another 106 mechanisms, we can build on best practice and also help us to be better prepared. So I think on those three are my inputs for now. Thank you, Chairperson.
Thank you. Honorable Nzimande.
No, thanks, Chair. You see, Chair, I'm worried that we put the cart before the horse. Probably the sequence of events should be, if this is what is being proposed, that the first thing is for us to push and or advance the paragraph 20.17, and the subject to that then can all other follows, including the implementation of the findings, because it is likely that you may discover things that you are not even aware, and not necessarily also covered by this forensic investigation. I'm worried also about the vagueness of the report itself in some important aspects, raising hanging allegations, in particular when it comes to politicians, with no concrete evidence which is expected of any forensic investigation. That seems to be just creating unnecessary political cloud to advance a certain goal which one may not know what will be that goal, whether a goal will be to see that municipality really under question, because the way the council is constituted, people are said to be involved in corrupt activities, though there are no concrete evidence presented through this forensic investigation. Then we are likely to be trapped to a situation where we play unnecessary political game being used by a certain administration, where if it's not have a proper influence over a certain municipality. I'm not casting doubt to any administration, but I'm worried that if we are blindly going to accept things that are so vague in some instances, which obviously hit the heart of the credibility of those that should be running the council, we shall have a problem if not really convincing or cogent information is presented to ensure that we act, and we act decisively where we are expected to act decisively. So I'm just simply suggesting that on top of everything of what is written, it's an oversight, and all other things should be subject to the findings or interaction that we'll have in terms of 21.7, whether you implement in the manner that you intend to implement. But furthermore, obviously, we want to suggest that, you see, if you want to be selective, that's why you are raising some concern, some suspicion. If you are selective to say you pick up a municipal manager, pick up a mayor and councillors, but in the value chain, in terms of the application of PRECA, whether you offer directly or indirectly any gratification, you are also guilty as them. But if you have a finding that only elevates some individual out of the whole value chain of corruption, if there is corruption, then it creates a problem. It means you are not applying the law the way it should be applied. And that's why I suggest that, Chair, the first thing, which is the first prize, is to go and engage there, then make our own decisions in terms of whether really we support the implementation or with amendment. Thank you.
Thank you. Honorable Bedenost. Honorable Bedenost, are you still there?
I'm here, Chair. Sorry, my internet connection was unstable for a few seconds. I apologize. I'm going to keep my video off. Honorable Chair, I think there was a forensic investigation and there was findings in terms of that investigation, and we must trust that forensic investigations are done with due diligence, and recommendations were made in terms of that. I think it's really important in our oversight function not to interfere in a municipality's internal workings, but in oversight to ensure that the findings of those forensic investigations have been implemented. So I agree with the Honourable Skeerkogel that we investigate whether the findings have indeed been implemented. I think it's also really important the seriousness of the criminal charges that were laid. If I read correctly in the report, there was corruption, fraud, and racketeering, which are very serious charges. We should follow up, I think, on a more serious nature with the Western Cape Provincial Police Commissioner on the delay. Why it's taken so long? I think it's 7 years now since those charges were laid. Why those cases have not been concluded yet? And if there was delays, what were those delays? It's unfortunately way too often that cases like these are set on the side burner and do not take precedence, and therefore they are I think a good space for us to do oversight over that. And to that point, maybe if I can request, Chair, because we're doing quite a bit of oversight, and we many of our reports include timelines, 21 days, 14 days, 30 days, 2 months, and we as a committee will lose track very quickly of when those timelines expire and what the consequences are thereof. So it might be useful if we can get a matrix explaining what the different oversight we've done where, and what timelines we've established, and when they expire, and what the next step is. We can maybe every now and again at a meeting have a presentation on that matrix and see what has expired and what the consequences, what our following steps will be now that that timeline has expired, because I'm afraid we set these timelines and then we forget about them. That's my input. Thank you very much, Chair.
Thank you. Honorable Kanya Ceza.
Thank you very much, Chair.
Ngiyaqala ukubiza ngegama namhlanje.
I noticed, Chair, unibiza ngelenkobe igama, show of course. Siyabulela, Chair. I'm sure amadzana ayabonga nawo xa beva unibiza ngelo gama.
Ayavuya.
Ayavuma camakho. Chair, if you can go back to 19.14, as Committee Secretary. No. 19.14, if you can. But if I can read it just to say.
Is there a problem there, Dr. Mtimkulu, to move? No, 19.14.
Okay, so I'll move now, Chair. My laptop is frozen, Chairperson, but I'm going to switch off and switch on again.
Yeah, do it that way. You can proceed, Honorable Ceza, whilst you are waiting, because you've got it there. You can make your comments. Unmute, Honorable Ceza. You have muted. No, he's gone. Let's try and welcome him back. But in the meantime, let's take Honorable Peter, whom I learned yesterday that he's no longer Honorable Peter. He's been renamed by Minister McPherson as Honorable Peters.
Thank you, Chair. Chair, mine is to just to support Honorable Skirkochel. I fully concur, Chair, based on the fact that timeframes is the key to this select committee. If our work, it won't be driven by execution, we won't finalize our targets. So I fully support it. He just put the words that I'm supposed to put. Please, Chair, I just appeal to the committee. Let us be special. Let us not be the same administration of the previous administration. Let us be special more than ever, so that whatever our term of office come to an end, we can know that our time frame is also finalized. I so thank you, my honorable Chair.
Thank you, Honorable Peter. Let's try and accept back Honorable Ceza and Honorable Molokome, who have been kicked out by the system. Honorable Mabibo, it's now your turn. Hoshi Mabibo.
I honorable scared on this matter because there is forensic investigation which is underway, and then there are serious allegations of fraud and corruption by the non-compliance by the councillors, and then mismanagement fund in this report that have, and then the recruitment of people with dark clouds. So looking at all this paragraph, I'm not going to single out. I will just say that we don't have to interfere with the forensic investigation. That is my take. That is my take, Chairperson. Thank you very much.
Thank you, Honorable Mabibo. Is Honorable Eza back? Please, let's accept them from the lobby. I'm sure they are trying to knock at the door. Those were the hands raised. I think most of the comments were just to enhance, especially on the timelines, so that we can keep the track of what is being done to respond to these forensic investigations. But we are not intending to, by staging a visit, we are not intending to restart the investigations. Investigations have been conducted and there are findings and recommendations. We need to be more interested on playing oversight over what has already been recommended. If there are people who are cited on the reports, but not appearing, their names appearing in our report, we'll be playing an overall oversight over whoever who was mentioned in that report, that they are consequence managed. Then 3, there is what we call a matrix facility that we have created, but it's correct that Honorable Berenhorst is raising that it should be presented so that we don't lose sight of what we have resolved. Where we say within 7 days, within 14 days, within 21 days, within 3 months, we need to follow up on those things. And within our team, in the chairpersons and the committee personnel, will allocate one individual who will be seized with that to trace that, because Mr. Manele has got a lot on his hands to handle. So he may sometimes forget to follow up on that. So we'll give it to a specific individual within the collective of administration to track all our, we have long resolved on a number of visits that we've conducted. So when we reopen, we'll present such a matrix to indicate which reports have we received and which one have not, so that we can call those who have not adhered to our recommendation, because our recommendation must be respected. But we are the ones who should respect them first by ensuring that we follow up on all what we have resolved. So we'll put that, it's already there. We have developed that matrix, and it's just that to enforce its implementation. I think we've taken into consideration what members have raised in relation to attaching timelines, so that we don't become vague on what we want them to do. We must give specific timelines in regard to that. Mr. Manele, anything?
Chairperson, thank you very much. Chair, I think we have summarized it quite well.
Recording
that
stopped.
We've got a tool that is called resolution tracking mechanism in a form of matrix and export. And with how we have explained it collaboratively with official in NCOP, when members come back on 2026, we'll ensure that in our first meeting, all the resolution involved in the oversight visit / budget vote will also be captured, the deadline, and provide a progress report in respect of what the committee has resolved. Thank you very much, Chairperson.
Thank you. Honorable Kaza is not yet back. So can we get a mover for the adoption with the amendments made? Honorable Skirkoka.
Chair, I make a proposal that with the amendments that, all of us are in agreement that it will be then accepted as such.
Thank you. Any seconder?
Peter, seconded, Chair.
Honorable Peter and Honorable Mabibo, second. So the report is now duly adopted. We are preparing, we'll secure a date for the presentation of the report to the NCOP early next year. And we'll take advantage of this period to effect all the changes that we have spoken about. Honorable members, Mr. Manuel, do you have minutes?
Chair, with your permission, when I reviewed the system problem, apparently I did not share in time. It will be unfair to share with members. If you agree, Chair, the minutes, the proceeding of today and the minutes of 25 will jointly be presented when we consider our report. Thank you, Chair.
Okay, thank you very much. Honorable members, this was our last meeting. We'll meet early next year because it's not going to be feasible to meet next week. We had scheduled on the 9th the engagement with the department, but looking at the other commitments, we have realized that maybe we better, so that we give it necessary time and we do justice in receiving such an important report from the department and our legal units. We thought it should be proper if we schedule for early next year when we reopen, instead of trying to squeeze it within this very tight holiday period. We are not yet on holidays. We still have a plenary to be attended tomorrow. We still have a plenary on the 17th of December to finalize issues of budgets. So it's still a long journey up until we close. But we wish to thank you, honorable members, for the work that we have conducted during the course of this year and the level of commitments and dedication that we have displayed. It really shows that we are all committed in working and executing our responsibilities. And a number of bills that we have processed and that we are still have to finalize. It shows that we are able to multitask, to deal with oversights on the other side, also to process the bills, to deal with normal issues that are scheduled in our program. So that on its own, it makes me to express our words of gratitude to all of you as members of this committee. Even when we go out to oversight, you are there in numbers. So that shows a high level of commitment and dedication. Let's keep that. And the level of unity that you are displaying, because unity does not imply that we are not going to be having differences. We may have differences, but we need to learn how we manage such differences, but in a cause of action to ascertain that we serve our nation. So that on its own, it shows the strength and capabilities of you as members of this committee. Let me declare openly, I'm blessed as a chair to have members of your magnitude in this collective leadership. So we remain committed, we must continue. The closing remarks I've made when we're saying goodbye to our stakeholders, they are still remain the same. We wish you a Merry Christmas and a prosperous New Year. Let us be all safe. We have to come back, all of us, without losing anyone. And we pray to God that may we be protected with our families during these holidays, and all committee members, residents of South Africa, and the reduction of gender-based violence and femicide, as well as general crime that is engulfing our nation. We pray and we call for the divine intervention so that all these social ills get rooted out in our society, but we remain a strong nation with resilience to continue to serve our communities, to root out the corruption so that our communities can be served better. And all the legislations that are aimed at changing the lives of our people for the better be effected during our term of office. With that, honorable members, really, we thank you a lot. And we thank our team members, our personnel, support personnel. All of them, they are committed. All of them, they do their work diligently, and they show high level of professionalism and ethical behavior in executing their administrative work. We really appreciate to have a team like you, a team that is highly committed, and we wish you and your families that protection up until we all come back. I now declare, with powers vested in me, I declare this meeting not adjourned, closed. Thank you very much.
I hope you met with the chairperson of public infrastructure.
Oh, yes, yes.
You'll give us an update.
Honorable Nzimande, I like your memory. Yeah. We were supposed to indicate to you. We had a meeting with Honorable Badenhorst and the team management team. They did report their frustrations that they are finding themselves with, especially on the non-responsiveness from the countries that we want to go to visit. But they are still working on the details. We have resolved in that meeting on your behalf as the chairpersons that if they continue not to be responding, we'll meet with DECO and the minister to try and support
Recording
us
in progress.
embassies to reinforce our planned study tour. But if it forces that we identified more than 5 countries, so if they continue to be non-respondent, we'll have to move to other countries. That's what we have resolved. But together with Honorable Badenhorst, my co-chair, we will be writing to the minister for his intervention as well. But our team has been doing their level best to try and secure this. We've just been delayed by non-respondents, especially from the countries that we envisage to visit. So, but we are working on that as we have reinforced, and we'll take that way forward because we want this tour, this study tour, to happen in our lifetime. When I refer to our lifetime, I refer that within this term of office, but early next year we should go and visit the areas that we have identified. But thank you very much, honorable members. We finished earlier. You can still have your lunch that I've packaged in your respective homes. You'll see how nice it is and well packaged. And now you can have the time to have your lunch. The meeting is closed. Thank you very much.
Thank you, Chairperson.
Siyabulela Mhlekazi.
Thank you, President.
Thank you, leadership. Siyaxolisa babuceza. These technical glitches sometimes happen. Thank you.